Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today on this channel, we're going to be talking about debt collection. Before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. I also wanted to let you know that the video also has timestamps. And if you're on a laptop or computer, if you're looking at the video, you'll see at the bottom of the video there's a broken line there. And every time you go to a certain portion in the broken line, you'll see that it's a specific topic. So you can use that to skip to different topics on the video. Or if you're also on your computer or laptop or on your phone, you can go to the description. And the way to get to the description when you're on your laptop or computer is to go to show more, scroll down from the socials, you'll see the time codes. If you're on your mobile, you just press the arrow button and it will show you the description. You also scroll down until you get to the time codes, and then you just press on the blue portion on the time codes and it will take you to that particular time and topic on the video. Now back to our video. In this video, we're going to be talking about debt collection in the context of recovery of loans. We're going to be talking about repossessions in relation to vehicle finance. Now, what is debt collection? Debt collection in this context is where a person approaches the court to recover any money that they have lent to a third party. When a person has lent someone money, and this could be an individual, a bank, sometimes you even have companies that are called pawn shops. And in all this context, it involves some exchange of money. In the instance of a bank will give a person a loan in the form of a personal loan or a mortgage bond or a home loan. In the context of a pawn shop, the pawn shop usually exchanges money for goods. In some instances, the pawn shop will say to you, you can pawn your vehicle with us and we will give you X amount of money. And if you are able to pay that money back within a specific period, you can take your vehicle back. But if you're not able to pay the money in that particular period, then we will be allowed to sell it. Now, in the context of something like this, the pawn shop cannot and does not have the right in law to keep the item that you're pawning. For example, if you're pawning a vehicle and you've pawned it for 10,000 pula, because it's a loan per se for a certain item being used as security and that item being a vehicle, if you cannot repay that loan, the pawn shop cannot say, we will keep this vehicle. In terms of the law, the vehicle has to be sold to a third party. Otherwise, that portion of the agreement is considered to be illegal. Now, we will talk about contracts sometime in the course of this channel. Here, we're just going to be focusing on the fundamentals of debt collection. When a loan has been given to someone with certain repayment terms, and those terms of repayment are not met, then the lender can take the person that they've loaned the money to court. A matter in relation to debt collection is started by way of a writ of summons. In the writ of summons, the lender will be explaining the agreement between themselves and the person that they've borrowed money. They will be explaining the terms that the repayment had to be made, and then they will be explaining how they are coming to court. For example, they will say, I lent this person 100 pula. This person was supposed to pay me 10 pula every month, and they've only paid me 10 pula once. It has been 6 months, and now I want to recover my money. The summons has to be served on the person who has been lent money, being the defendant. And you can watch my video where I talk about court process, specifically summons, to see the various steps. Now, in debt collection, there's a possibility that you might find, especially in home loans, that there's a third individual. And this individual is sometimes referred to as a surety. A surety can also exist where the loan is being asked for by a company. In the context of a home loan, the surety comes in where the person who is asking for a loan is not the owner of the immovable property or house or shop that will be used as security. So in that particular instance, in suing, the lender, who would be the plaintiff, would have to sue the person who took the loan as the first defendant and the person who used their property as security as the second defendant. And this is important. When we go ahead in this video, we will demonstrate how. In the context of a company, because in terms of the law, as explained in my previous video on legal capacity and legal entities, a company is considered to be a separate legal entity from its owner, and that makes it a legal person. Now, as a legal person, the way the company operates is that it can shut down tomorrow and you can find that there is nothing in the company. And because you can't take the company into civil imprisonment and so on, sometimes it is required that either a director or a shareholder of the company be a surety for the loan that is taken by the company. Once the loan is not being paid and the writ of summons has been issued by the lender, being the plaintiff, then the defendant or defendants have the right to defend the matter. And in defending the matter, they can give various reasons for why they say this person should not get what they are asking for. Depending on what reasons they give for such, the court might agree or might not agree. And for you to understand the various scenarios, you can watch the video I've been referring to where I talk about court process, especially in relation to writ of summons and execution. But in this video, we're going to be dealing with the context where the plaintiff is successful at court. Now, where a plaintiff is successful at court, where it is a home loan, they can have asked for an order for the property used as security to be specially executable. This means that once the order is out, they can then get a writ of execution against immovable property. They can then sell that property, and in selling that property, they will recover some money. The sale of the property is done through public auction by a deputy sheriff. Now, in doing this sale, there have to be certain processes that have to be followed before the sale even takes place. And I deal with this issue in my video in relation to writs of execution. So in this context, I will be dealing with it in the general sense. The property will be attached by the deputy sheriff at the deeds registry. The deputy sheriff will then advertise for when the property will be sold by public auction. And in the advert, the deputy sheriff will advise that the conditions of sale of the property are available for any party who is interested to look at. When the sale takes place, it is possible that sometimes when you go and buy property at auction, the people in that property are still in occupation. And if the people are still in occupation, then the person who is buying based on what the conditions of sale provide will be responsible for evicting the people that are still in the property. Once the property has been sold, there is prepared what is called a plan of distribution, and the plan of distribution will show how the money has been used. You can find that in some instances, one property has been mortgaged more than once with different banks or different individuals. So when the property is sold, then the other mortgagees will then seek to participate in this sale. This means that once the property has been sold, the first mortgagee is paid, and if there's any money left over after the paying of this first mortgagee and the related costs, such as advertising, deputy sheriff, and so on, then the second mortgagee will be paid. If there is no money left over, then the second mortgagee will have to approach the individual for the recovery of the debt. Now, in order for the second mortgagee to be able to participate, they should have gotten judgment against the immovable property and against the individual who passed the bond. The individual here could be a company, or it could be a natural person depending on the context. And if it's a company, you find that there's another individual being a natural person who has signed a surety. Where the second mortgagee does not have a writ of execution, then they cannot participate. If there is no money left over, the second mortgagee will then approach the court and seek a writ of execution against movable property of the people. The people here meaning the company and the natural person that might have signed as a surety. The same is true for a first mortgagee who has sold the property, but the property does not cover the entire debt. If there's an excess amount that still needs to be recovered, they can ask for the issuance to them of a writ of execution against movable property of the individual here being the company or the natural person who has signed a surety for the company. Once this writ of execution against movables has been issued, then the movable property can be attached and sold. In addition to that, if the movable property is not enough to still satisfy the debt, then they can get a second writ of execution against immovable property. Now, a distinction must be drawn here in relation to immovable property that is specially executable and immovable property in respect of the third writ of execution. The first immovable property that is specially executable would have been the one mortgaged to the lender, who is the plaintiff. The second immovable property that is being sought to be attached now would be some other immovable property that the defendant or defendants have that is not necessarily specially executable. If there is no other property, then the execution process follows that which is set out in my video dealing with executions. Now, one of the things that a plaintiff who is a lender has available to them is civil imprisonment. However, when a person goes to jail for a debt for 30 days or however many days, that does not mean that the debt is wiped clean. When they come back from jail, they still have to pay that debt. If they are unable to pay the debt, then they can keep being taken back to jail. Now, the risk here is that if the person is constantly being taken to jail for failure to pay debt, and they continue to be unable to pay debt, the court might say it is clear that this person has nothing, and therefore I will not continue to issue orders for their civil imprisonment. Now, the debt collection process, although started at court through writ of summons, usually the person who is owed, being the lender, will try and reach out to the person given the loan before they even instruct attorneys. Once they have instructed attorneys, the standard operation, but this is not always the case, is that a letter of demand is sent out to the debtor. And the letter of demand is sent out at this point in time so the parties can try and negotiate without first having to go to court. The mistake that a lot of people make is once they receive this letter of demand, they then sit back and do nothing, or they go and talk to the lender. It's usually best for the person to try and talk to the attorney, because the instruction to the attorney sometimes does not arrive quick enough to stop them from approaching the court. When a person is served with a writ of summons for debt, they must act. They should not sit back and assume that the matter will fall away. Now, later on in the course of this channel, we're going to be talking about service. And when I talk about service, I mean service of court papers. Because people don't seem to understand what constitutes service and what does not. If you are given court papers at a particular place and you don't want to take them, that, depending on the context, can be seen as proper service. But I will deal with this properly on a video related to this particular issue. One important thing to look at is in the course of negotiations, the parties might seek or want to change the terms of the original loan agreement. And this can be done by way of signing of what is called an acknowledgement of debt, where the debtor says, yes, I owe 100 pula. I was asked to pay 10 pula every month until I finish this debt. Unfortunately, I can't do that, and therefore I propose to pay 5 pula a month. If the lender agrees, then the debtor signs the acknowledgement of debt. A repossession usually happens in the context of motor vehicle finance, but can happen in the context of other forms of movable property. We're going to be using vehicle finance here as an example, where a person is bought a vehicle through a loan by the bank. In a lot of situations, you find that in terms of the agreement between the parties, the vehicle will remain the property of the bank, until the loan is paid off. If the person does not make the monthly agreed installments for this repayment, or whatever installments have been agreed between the parties, then the bank can approach the courts for repossession of the vehicle. And the reason why it is repossession is, like I said, this property in terms of the agreement still remains the property of the bank. This is the situation even if the registration book, or what is commonly known as a blue book, is in the name of the debtor. And the bank, in going to court, will be asking for the car back in order for them to sell it. This repossession is done by way of application, and the application is served on the person who took out the loan, or if the person who took out a loan is a company, then also on the person who would be the surety. These would be the first and second respondents, and the person who is bringing the matter would be the applicant. The applicant will serve the application on the respondents, and I've set out in my video on court process part 2 what happens and the steps to be taken in the application process. If the respondents have a good reason for why the applicant should not be given what they want, they should put in what is called a notice of opposition, and then they should actually file an answering affidavit where they respond to what is being said. In relation to debt collection for purposes of a summons and recovery of a loan, when a person does not defend the matter, then the plaintiff is given default judgment. This default judgment they get when they apply to the registrar of court and say, "Registrar, I have served the summons on the defendant, and the defendant has not entered appearance to defend within the given time, and therefore please grant me judgment against them." And together with the application for default judgment, they will seek to be issued with a writ of execution. And in the writ of execution, in relation to a movable property, the property will be said to be specially executable. But if it's an issue of a personal loan, it will simply be a writ of execution against movable property. In application proceedings, however, where the person does not oppose, then the applicant can set the matter down before the court and ask for a date for them to move their application. However, if enough time has passed, they can simply ask the court for an order for repossession. Once the order for repossession has been granted, then the deputy sheriff will use that order to go and take the motor vehicle from whichever party is in possession of it. It could be one of the respondents or the respondent's representative or any third party. The vehicle will then be sold by auction, and if enough money is recovered, the excess will be given to the debtor. If there isn't enough money recovered, then the excess debt will be used to bring proceedings against the parties for the recovery of the debt. And this is done through a writ of summons. Similar to where it is a loan for a personal loan or a mortgage bond, there is also a plan of distribution that is prepared to show how the money recovered from the sale of the vehicle was used. Now, once there's this excess debt, the process follows the general process of debt collection of a simple loan, where there's a summons issued. If there's no appearance to defend, then default judgment is granted and a writ of execution against movable property issued, and so on and so forth. That is the debt collection process in a nutshell. Please, if you have any questions or comments, put them in the comments below. Like, share, and subscribe. And thank you for joining me. See you in my next video. Bye.